afternoon. For the second human rights conversation organized by the UCD Center for Human Rights, I have the pleasure to welcome Dr. Edardo Celeste. We'll talk about COVID-19, tracing apps and privacy, an EU perspective. Well, first of all, I'd like to introduce our guest. So, Edardo, you're Assistant Professor in Law, Technology and Innovation at DCU, Dublin City University. Your research interests lie in the field of digital rights and constitutionalism, social media policy and regulation, privacy and data protection law. From 2016 to 2020, you were an IRC doctoral scholar at the UCD Sutherland School of Law, and you have just finished your PhD there. And this is where we met, and congratulations on finishing your PhD. You are now at DCU, and you are the principal investigator of a major research project entitled Digital Constitutionalism in Search of a Content Governance Standard, and this is funded by Facebook Research. Now, so Edardo, today you will be talking about a topic which has been of concern to governments, policymakers, lawyers, and especially human rights lawyers all over Europe during the pandemic disease. Since these so-called tracing apps have started to be used during this time. And although some countries have yet to launch their own apps, it's still on the cards in view of a possible second wave of the COVID-19 disease, unfortunately. So during the pandemic, many of our rights and liberties have been restricted by governmental measures. So my first question is that, as has been also the case in relation to the rights to privacy and data protection, that there have been restrictions to these rights?
So many thanks, Marie-Luce, for your introduction. This is really like an interesting question. So no, in contrast to other rights, such as, for instance, mobility rights, no governmental measures have restricted the right to privacy and to data protection. However, the paradox was that by restricting our mobility rights, we have essentially increased the use of digital technology tools. And this in turn has essentially amplified the potential risk of violation of our right to privacy and to data protection. So we have all seen recent satellite pictures of Europe depicting a scenario that we've never seen before. Even the busiest airport in Europe have become quite grass fields, and our cities have been unusually desert and silent. However, of course, human life has not ended, was only hidden. So it puts us in our houses, and of course it flows in the virtual world. So when, paradoxically, individual mobility rights are restricted in the physical reality, it's here that it's the moment where our existence migrates and flourishes in the digital space. And this is the reason why we are exposed to so many threats that, of course, information and communication technologies may generate to our fundamental rights.
Okay, thanks very much. So now that the restrictions on mobility rights are ending, for the time being at least, do you foresee a decrease in the use of digital technology tools and as a result in the potential number of violation of rights related to these tools?
So I think that the restriction of mobility rights has certainly been one of the main drivers pushing us towards an increased use of digital technology during the COVID-19 pandemic. Although part of our digital life, in my opinion, will end with this gradual lifting of mobility restrictions, technology will continue to play a significant role. And in my opinion, not only as a source of information, as a means of communication, but also as an instrument to fight the spread of the virus. So in this phase of relaxing containing measures, mobile applications are offering contact tracing and warning functionalities. And they will definitely help limit the transmission of the disease from individuals that have been tested positive.
Okay, so precisely talking about these mobile applications, and you have answered that to an extent, but what is the exact function of these kinds of mobile applications?
Yeah, so essentially those mobile applications can play different functions. So a first layer is essentially application which inform people. And the paradigmatic example was the World Health Organization, which decided to use the mobile application WhatsApp to provide people with the useful information about the pandemic. Another function is, for instance, to check the symptoms of individuals. So individuals are able to answer preset questions and therefore assess whether they are at risk of having contracted COVID-19 or not. There could be telemedicine, mobile application, and of course, there are contact tracing mobile applications as well. So these contact tracings, mobile application essentially aim to help people essentially remembering the individuals with whom they enter in contact with. And in this way, they can help health authorities, for instance, to require those individuals to self-isolate and therefore stop the further spreading of the pandemic.
Okay, thanks. And then from a fundamental rights perspective, is there any risk associated to the use of these apps?
Yeah, so these, especially the last kind of apps that I mentioned, contact tracing apps, have been in the spotlight of the past few weeks and are currently subject to an intense debate in Europe due to their potential risk for individual privacy and data protection. So in a nutshell, the main risk, the main fears are related to the possibility that similar instruments are used to track the position of individuals, to monitor their social interactions, to store sensitive health data, and potentially to reuse this data for other purposes, such as law enforcement, or even to justify the imposition of longer-term mass surveillance regime. And of course, I would say that such a sense of trepidation is somehow justified in Europe, especially in light of our past. But even if we look at other countries, we know that unfortunately there are countries in which such systems of mass surveillance are already in place, such as in China or in Taiwan.
Yeah. So yes, of course, the concern is about mass surveillance, or at least a surveillance which is out of control and out of judicial review oversight. So then what has been the reaction to this concern at European level?
So at European level, one can lament a certain delay in reacting, in providing a sort of like coordinated and adequate response to such conjectures. Because amid this internal trepidation, national governments have acted as, I would say, solo instruments in search of the right contact tracing app. So they've hastily organized call for tenders, and they've essentially heavily relied on private corporations or spontaneously emerged scientific consortia. It was only on April the 8th that the EU Commission announced for the first time the imminent creation of a common toolbox on the use of digital technology to contrast the spread of COVID-19. And unfortunately, at the time when each member state had already lost this sense of being part of a sort of like the European orchestra, and when the free movement across borders seemed a thing of the past. But then the Commission rightly recalled that a lack of coordination in the deployment of similar apps could hinder the potential of these measures and could significantly impact the functioning of the single market and ultimately enhance the risk of scattered fundamental rights violation too.
Okay, when you say scattered violation violations of fundamental rights, is that these would be isolated violations and in some member states, and that would be difficult to identify them and then to address them. Is that right?
Yes, yes,
Okay.
exactly.
Yeah. So then what have been the measures concretely adopted at EU level?
So essentially, after this first phase, when the Commission recognized the need of adopt a common toolbox, the Commission promptly, I would say, baptized a new institution, which is the e-health network. I say baptized because in reality, this institution, which is composed of the representatives of a national health authorities, was originally created in 2011, but was only in October 2019 that the Commission adopted the functioning rules of this for this institution. So on April the 15th, the e-health network adopted the first series of recommendations to design contact tracing apps in Europe. And these were followed some days later by a guidance from the Commission and by a set of guidelines from the European Data Protection Board, which is the institution which is composed of European and national data protection authorities. Now, reading together these documents, I think that the response given by the EU to the fears of these incumbent mass surveillance regimes has been very clear. Because the General Data Protection Regulation, which is the new pan-European legislation regulating data protection in Europe, and the e-privacy directive, which is the legislation regulating online privacy of electronic communication in Europe, explicitly prohibit the bulk collection, access, and storage of health data and location data. So essentially, from the analysis of these documents, one can understand that what contact tracing apps can do is only to process proximity data. So proximity data are not the information about the location, the geolocation of an individual, but they're only information about the likelihood of a virus transmission based on the epidemiological distance and the duration of contact between two individuals. So essentially, the European Commission recommended that those apps in Europe will use the Bluetooth technology and not, for instance, the GPS technology, because they will have only to process the distance and the duration of in terms of a proximity between two individuals and not the actual location of two individuals.
Okay. Yeah, so it seems that the response given at EU level is reassuring in a sense.
Yeah, absolutely. So essentially the Commission and the European Data Protection Board have reiterated and strongly affirmed that for instance, only national health authorities should play a primary role, possibly as data controllers, and in this way depriving private companies of the power to define the purposes and the means of data processing. They've said that, for instance, a user's data should be at least pseudonymized or not to say, when possible, of course, anonymized. So, and those data should be stored securely and automatically deleted after a period of time proportionate to the incubation period of the virus. Data must be used only for specific purposes, possibly defined by law, and should be reused only in the context of research. And of course, one of the points that the Commission made was that contact tracing apps should be interoperable and thus able to be properly used in a context where cross-border movements are resumed. And I think that is a very important aspect to bear in mind, especially here in the island of Ireland.
Yeah, so it's, precisely how is the situation in Ireland then?
Yeah, so here in Ireland, the HEC, the health authority, the Irish Health Authority, originally announced the launch of a contact tracing app by the end of May. However, no definitive launch date has been confirmed yet. So the question of the interoperability of contact tracing apps is particularly important on the island of Ireland because of the coexistence of two jurisdictions, the Republic and Northern Ireland. The UK, which has officially left the European Union last January and now is in a transition phase until December the 31st, has delegated to its constituent entities the choice of identifying the most suitable solution in terms of contact tracing apps. What is interesting to notice is that Northern Ireland will adopt a contact tracing app which is different from that adopted in the UK and different from that adopted in the Republic of Ireland. And therefore, one may understand that it will be really crucial that the interoperability of this app with both the English and the Irish app will be guaranteed. And, because I think that only in this way, digital technology can be simultaneously at the service of public health, facilitate freedom of movement, and of course be respectful of the rights to privacy and to data protection.
So there is much more to talk about concerning the topic, obviously, and I will encourage colleagues to read more about your research. I understand you will pursue on this in follow-up research in blogs, etc. So I've mentioned before that interested colleagues may contact me or you on the DCU website. You have your address. If you have questions about your research, we're very happy to have you as an associate member of the UCD Center for Human Rights. So I wish you all a nice end of afternoon and thank you for watching.
Thank you very much indeed, Marie-Luce.
Thank you. Thanks.
Bye.